Hello everyone, I'm back to do a quick lecture on freedom of speech for con law. This is part of our individual rights lectures. I've done the first one, which was based on your freedom of religion. Now we're moving on to freedom of speech. The First Amendment protects individuals' rights to free speech and is applicable to the states through the 14th Amendment. So remember, if you're working with the states essay, you do have to write this entire rule. And I see this rule on every single essay that I read, or their model answers, or in our practice essay books, all of that. So we'll use this rule for freedom of speech. There's two classes of speech. Content-based is the first one. This is speech regulations are those that forbid the communicative impact of the expression. So if you read an MBE or an essay and they're regulating the communicative impact of their speech, then we're going to do content-based formula here, which is strict scrutiny, and it's rarely allowed, okay? We use strict scrutiny, which means the regulation must be necessary, which is narrowly tailored to achieve a compelling governmental interest. Those are your elements. Fact triggers for these on MBEs and essays: banning events promoting particular views, banning a specific action or conduct, banning specific content or types of content, and banning the sale of specific items. So I've seen some MBEs on this and essays on the ones that I just pointed out. So content-based, they are regulating communicative impact using strict scrutiny, and these are the elements right here. We're going to talk about the unprotected categories of speech. For the unprotected categories, the government must regulate in a content-neutral way. So IS, which is intermediate scrutiny, and we'll go over that in a second. The unprotected categories are obscenity, misrepresentation or defamation, imminent lawless action, or fighting words. First, unprotected speech is obscenity. The rule is considered obscene if it describes or depicts sexual conduct that, taken as a whole by the average person, is these three elements: appeals to prurient interest in sex, patently offensive, and lacks serious literary, artistic, political, or scientific value, which I remember as lapse. So if it's obscene, you need to prove these elements here. Next one, misrepresentation or defamation is a tort, so look to your tort lectures for that. Imminent lawless action. The rule: the government can ban speech advocating imminent lawless action if it is intended to incite or produce an ILA and is likely to produce such action. So I've seen some MBs on this one also. Fighting words are next. Fighting words rule: words that are likely to cause the listener to commit an act of violence. They must commit the act of violence, not just get angry. So anger alone is no, not going to happen. So fighting words, they must incite the person to actually do an act of violence, okay? Those are tricky on MBEs. Lots of MBEs on those too. Now we're back to content neutral, the second type. Content neutral is communicative conduct. Regulation is aimed at something other than the communicative impact of the expression. Okay, so this is more of a conduct here, not the expression of what you're trying to say. Content neutral regulations are allowed if they are IS, intermediate scrutiny, serve a significant important government interest, are narrowly tailored to serve that interest, and leave open alternative channels of communication. I see tons of MBEs and essay on this one too. Time, place, and manner, TPM. Restrictions seek to regulate speech based on the time, place, and manner in which the speech may be communicated. All speech must be viewpoint neutral, or they are content-based and strict scrutiny. Okay, so if they are not viewpoint neutral, then you're going to use your strict scrutiny and consider it content-based. If they are viewpoint neutral, or not. So the rules differ on types of forum, the type of forum that's in the essay question, or type of forum that's in the MBE for TPM. So there's public and designated public forums, and there's limited and non-public forums. You need to know which type of forum you're in. Now, public or designated, generally open to the public. Okay, so the public forums are generally open to the public. Now, the designated public forum means that it's not traditionally open to the public, but for sometimes, rarely, it's open for a specific purpose. So it's not always open, but it is for this specific thing that they're trying to do, what speech they're trying to make there. Okay, both of them must meet IS, intermediate scrutiny. They both must be content neutral and viewpoint neutral. Remember what I just said. If they're not viewpoint neutral, then we go back to our If they're not viewpoint neutral, they are content based, and you were going to do the strict scrutiny test instead of an intermediate scrutiny. You do have to memorize that. Okay, so if they are, they must meet content neutral and be VP neutral, serve a significant important government interest, which is of course is intermediate scrutiny, narrowly tailored to serve that interest, and leave open alternative channels of communication. So we argue all of these with our facts. Limited non-public forums, opened for limited use by certain groups. Non-public means they're absolutely closed to the public. They must meet the rational basis test, the easiest test to meet, right? Be VP neutral, serve a legitimate government interest, and be reasonably related to serve that interest, okay? So that's the rational basis test for limited and non-public. Commercial speech, advertising, this is like advertising. The government may restrict if the regulation serves a substantial government interest, directly advances that interest, and is narrowly tailored such that there is a reasonable fit to serve that interest. So basically all of these elements need to be memorized for each one, even commercial speech. Then we have symbolic speech, which is freedom to communicate an idea by use of a symbol or communicative conduct. The government may restrict the regulation if it is within the constitutional power of the government to enact, furthers an important government interest, unrelated to the suppression of speech, content neutral, and prohibits no more speech than necessary. Important government interest means that we're doing the IS test, intermediate scrutiny test for symbolic speech. And I've heard of symbolic speech, but it is a symbol. So using a symbol, so like the flag or things like that. I remember the one about burning the flag, symbolic speech, okay? Limitations on free speech regulations, okay? So these are the limitations. You do always have to throw these in. Is the regulation too vague? Is it overbroad? Is it unfettered discretion, or does it have any prior restraints? Let me give you some rules on all of these really quick here. So if it is vagueness, a speech regulation is unconstitutionally vague if it is so unclearly defined by a reasonable person. A reasonable person cannot define what they want out of this. Overbreadth, a speech regulation is unconstitutionally overbroad if it bans both protected speech and unprotected speech. Overbroad, banning too much. Unfettered discretion, a regulation, licensing scheme, or permit, this is usually about permits. Regulation is unconstitutional if it leaves unfettered discretion to the decision maker, okay? Or by not setting forth narrow and specific grounds for denying a permit, or where the permit mechanism is not closely tailored to the regulation's objectives. Prior restraints prevent speech from being heard before it even occurs. They're not even letting it occur. They're just not going to hear it at all. Collateral bar rule, a prior restraint is issued already, and one cannot violate it first and then defend oneself by asserting that the action is unconstitutional, even if this is correct. Okay, so they just try to assert it first. So that's it for our speech. Make sure you throw these limitations in there, because these are always on essays and they're always on MBEs also. So make sure you know those and how they work. The approach. See my drawing. I didn't do a drawing approach for this one. Let's see here. We could do it really quick. Commercial speech, content neutral, time, place, and matter. Yeah, so we're going to go to con law approach. So basically the con law approach is JSPFLLI, and I'm giving this to you guys for every lecture that I've done. So J is for justice stability. We need to know everything in justice stability. This is the main issue, but what are the branches to it, like mootness, ripeness, all of that stuff, 11th Amendment, so those have to be memorized. State action, P for power of the states. What are the power of the states? What are the power of the federal powers? What are the limitations on state powers? Remember those, and limitations on federal powers. Those are all my other videos, and now I'm working on individual rights. So far, I've just done the freedom of religion and freedom of speech, so I'll work on the next ones on my next video. Good luck on the bar exam, and do lots of MBEs on this, lots and lots, and write up lots of your approaches for speech essays. So go through essays and spot the issues. That's most important on the speech ones, to get all the issues, especially when it comes to if they have any unprotected categories. Write those up. Or time, place, and manner. You'll know time, place, and manner because they're going to give you a time, a place, like a time, like a clock time, and a place. Okay, symbolic speech. And don't forget the limitations. These are big, vague, overbroad, unfettered discretion, and prior restraints. Okay, so I'll see you guys on my next video.